Hello friends, did the High Court of your respective state has dismissed your writ petition? There's nothing to worry. There is something called the Letter Patents Act 1865. It is an age-old British act that is still there in the entire country, which has established the high courts of judicature in our country. The first high courts were established under this act, and it has got an express provision of letter patents appeal. Whenever there is a single judge decision which has gone against you, you can take it to the division bench. That is, two judges will be adjudicating that particular petition of yours, the order of the judgment of yours. So under Letter Patents Act, you can take a letter patent appeal, that is a writ appeal, to the division bench of the High Court and get it adjudicated and get an appropriate relief. But that will be on question of law. The question of law will start from the writ petition itself, and it will proceed to the writ appeal as well as to the special leave petition. So one has to be very careful while drafting and arguing your writ appeal or writ petition or an SLP. These are all the very important things, because the writ petitions are not maintainable on question of facts. They are maintainable only on question of law. And also remember, if at all there is no efficacious remedy readily available any of the statutes, the high courts have got ample powers to give you or grant you a appropriate relief or remedy, because the courts are above statutes. They are the lawmakers. Whatever the single judge or a division bench or in the High Court or the Supreme Court, the judges, they are giving you the relief itself will become law. So you can always get appropriate reliefs, provided if you are being represented by the best advocates who have got good knowledge only on the particularly on the question of law. The biggest mistake what the clients do is they bank on most of the facts. The facts will really irritate the judges of the constitutional courts. You are not supposed to argue on facts. Only a foolish lawyer will argue on facts. What is a lawyer supposed to argue is on the question of law. That is very important. The legal position, the legal grounds, what you have, why are you seeking an appropriate relief. If at all there is no legal ground or question of law, then you can request the judge that to give you grant you an appropriate relief that you are praying for, explaining your facts and circumstances, and trying to take a relief which will itself will become a binding precedent, and it will become a law. That's all, my dear friends. Thank you.